Thank you. Thank you so much. See, this is going to be a good day because normally I have people who don't even stand up, and y'all stood up longer, so thank you. I appreciate that. We're going to get started in a moment. I'm going to give the prosecutor a chance to finish up the pretrial that she's doing really quickly. Ms. Black, good morning. How are you?
I'm good. Robert?
Yes.
How was your holiday, Your Honor?
It was wonderful. How was yours?
Great. How's the sandwich?
Wonderful.
Good, good.
Haven't seen you in a while.
In passing.
That's right, in passing. All right, everyone, thank you for your patience. A few important matters. Every time we start, I have to make sure you understand what your rights are. Your first right is to remain silent, which means technically when I call your name, though you do come by, right in front of that partition, you don't make a statement if you don't want to because you have the right to remain silent. Your hands must be visible. But again, you don't have to make a statement. And if you remain silent, what we will do is maintain that you're not guilty, which will reset this for another hearing or possibly a trial because you do have a right to a trial or a full hearing. Trials are before me in regard to misdemeanors. If your case is here in this court, you can have a trial. The trials are called bench trials unless you make a request in writing for a jury trial. Before either one of those, we will make sure that you know the evidence against you. And at the trial, you can cross-examine any witness that the city calls. And you can have your own witnesses appear. And if your witnesses won't come based on you asking them to, we will subpoena your witnesses for you. So you have the right to remain silent and the right to a trial. You also have a right to an attorney. We have a defense attorney who's here today to assist you. If you haven't had enough time to speak with her, we'll give you more time. Or if you want to bring your own attorney in, let me know and we'll give you a chance to come back with your own attorney. If you're going to resolve your case today, there are 4 types of pleas you can enter. The first one, not guilty, resets this for another hearing or a trial. You can also enter a plea of guilty where you are admitting what you're accused of. And if you do that, I could sentence you today. A sentence in a municipal court ranges from $0 to $1,000, 0 days in jail up to 6 months in jail. That's on a guilty plea and guilty finding. There's also a plea of no contest, the same, similar, or exactly the same sentencing. The difference is with a no contest plea, you're not stating with your own words that you're guilty, but you are not contesting the allegations that are being made by the prosecutor, which means we can get your case resolved. The good thing is a no contest plea cannot be used against you in a later proceeding. And then there's a plea of not guilty by reason of insanity. If you choose that particular plea, we'd have to stop the proceedings to see where you are and your ability to go forward. But keep in mind that plea is not available for traffic cases because the presumption is that if you're driving, you do have the mental capacity to handle the cases. All right. If you are here on a felony, you have a right to an attorney, you have a right to know the charges against you, and you have a right to what's called a preliminary hearing. That's a little different because it's not a trial. It's a hearing where the city has to put on some evidence to indicate that a felony occurred in this city and why they believe you are connected to it. Because if they can do that, what they're establishing is that the case is bigger than this particular court and it has to go to the county. So you can have that hearing or you can waive the hearing, which simply means you're allowing the case to be sent to the county, but you are still not guilty. The other thing I'll mention before we begin is driving under suspension has become a very expensive penalty case in Cuyahoga County. And what I mean by that is the fines average anywhere between $500 to $1,000. You get 2 points on your license. Your license could be suspended. And before COVID, some judges were even given jail time for this offense. But in this court, what we try to do is give you the opportunity to come back with your license or at least get in a position where you have driving privileges. With that being said, I keep the fines at the very minimum. And if you come back with your license, I reduce your fines from the minimum of $500. Then we also put you in a position where you're not getting any points. And of course, you don't get suspended or any jail time. So the goal is to put you in a position where you're driving valid and not driving under suspension. And if you need time to get that done, we'll offer that time for you. All right, I'm going to call the cases. And if you have any additional questions, the attorneys are available. Is it Dalen or Delon Craven? How's it pronounced? Dalen Craven. 21 TRD 04590, driving under suspension in a red light. It looks like what they are doing in your particular case is amending the charge to no driver's license. So that's an example of where I can reduce the fines. And what they're going to do is dismiss the second charge, and you've shown insurance. So you want to resolve the case with the amended charge, the lower charge. How do you plead to no driver's license? All right. So as opposed to the $500 fine, I'm going to cut it in half. It'll be $250 plus costs. The other charge is being dismissed, so you're walking away with no points on your license. And for everyone, if you cannot handle your fines and costs today, like for instance, when you go to the clerk's office and if it's a little bit more than your bond or anything that you have, within 72 hours, you can request a payment plan. If you have a bond, you can request a payment plan for the rest of it right now. But say you have nothing. Within 72 hours, come back with at least $25 down and we'll extend your balance out. Also, Mr. Craven showed insurance. If you resolve your case today and you don't have insurance, within 72 hours, come back with insurance, show it to the clerk's office so you don't get suspended. So all of that to say, you go to the clerk's office, they will apply your bond, and if you need time on that balance, we'll work with you, okay? All right, take care, sir. Shantara McKenzie, 22 CRB 00386. This is a charge of assault, where initially they were alleging that you committed a first-degree misdemeanor, but the city has amended it to a minor misdemeanor. The minor misdemeanor is not on your record as a criminal offense, and the maximum fine is a $150 fine. Is that how you want to resolve the case today?
Yes.
All right. How do you plead to that minor misdemeanor?
No contest.
All right. And based on what I have here, I'm going to accept the no contest plea with the fine of guilt, as opposed to a $150 fine. How old are you, ma'am? 22. And you spent a couple of days in jail, right? Are you working currently?
Yes, I am.
All right. No more fighting, right? All right. So what I'm going to do, as opposed to a $150 fine, it's going to be $20 plus cost, because I'm looking at what happened. I'm looking at it being a minor misdemeanor, and the fact that you spent 2 days of your precious time and life in jail.
I missed out on
Yeah.
days at work.
So, I'm going to give you a much lower fine, more so just so you just avoid this situation when you can, okay? All right, you just go to the clerk's window and take care.
Okay, thank you.
Camille Scott. Ms. Scott, 19 CRB 00142. This is a charge of falsification, where they were alleging that on February 1st, 2019, you did make statements knowing that they were false to police, as well as maybe a 911 call. And it looks like we are maintaining not guilty at this point, right? So what we'll do is reset this so that the attorneys can see how they're going to get the case resolved.
And Jeff, if they may please report, there's one other issue that we need to address with Ms. Scott.
Yes, go ahead.
Apparently she posted a bond that went into somebody else's name on a different case. And she spoke with Gloria about it. She presented me with a receipt showing it. Of course, it says it's paid by this other individual, but Gloria allegedly has information that it was this woman that paid it and that it should have went on to her case. And so she was asking that the court, apparently Gloria allegedly told Ms. Scott to address it with the court today.
Yeah, so a couple things. One is, if just taken for the fact that you posted a bond, the bond stays on the case until the end of the case. Hold on 1 second. Warrant block bond, when you post that to get a new court date, it will remain until the case is over. So that's the first, though. It'll stay here. The other thing we have to figure out, though, I think I was brought up to speed on what happened. And we can talk about it when the case is resolved, because as you know, even the warrant block that she posts, it doesn't, the day she comes to court, it doesn't get applied. It's when the case is over. It's your guarantee that you'll come back to court. So what I'm doing for you at this point is acknowledging that you have some type of block you paid or warrant so that you can continue to have this case going on. You understand what I mean by that?
No, because
Well, let me explain it one more time. So in 2019, you didn't come to court. Listen. You came to the window to post a bond for something, right? That gave you a new court date. So you're here today. Forget about everything else. That bond for you or anyone in this room will remain until the case is over. Right now, you're maintaining not guilty. So the case is not over.
the case was in 2016.
Okay, well, 2006, I'm reading the 19. Maybe that'll be your defense, because the ticket that I have in front of me says on February 1st, 2019. So maybe that'll be a defense you have. Did you see the ticket? Okay, did you talk with the attorney?
No, I
You didn't talk to her today?
I looked, yeah. Her-
Okay, because you just represented her.
Yeah, but and then my case is not the 19.
Okay.
That's somebody else.
All right, so your name is Camille Scott?
Yes.
Okay. Broadview Heights?
No.
Okay. Date of birth 2/26/89? Did you actually talk with the defense attorney?
Yes.
Did you explain this to her that she has a ticket from that date?
Yes.
Okay. All right. So even if she didn't, I just read it to you. Say, for instance, you never spoke to the attorney to your right. What I have in front of me is a ticket alleging that on February 1st, 2019, that you did make statements knowing that they were false to police over a 911 call, as well as to the officers while in the city of East Cleveland. That's the criminal charge. At some point, you didn't come to court for whatever reason. That means that there was a warrant block. You posted a bond at some point. That's what I'm hearing. So now you have a new court date so that you can maintain that, hey, I didn't do this because one, maybe it's 2016, maybe I was never even here. Okay, but you got to follow me first. Before we argue, follow me first. So you're maintaining that you didn't do this, which is your right. So today we're saying not guilty, and I'll see you when we come back to see if the city can prove that this was you. But the only way that even happens on a case this old is when somebody normally posts some type of bond or their warrant block they paid for, right? And you're saying you came up here and posted something, correct? Right, so that's why you're here today. So you understand that? All right.
That was for a warrant block for us to get behind it.
Okay, but do you understand why you had a warrant block on your
No, I don't.
because you missed court
Yeah,
in
I
2000.
seen that, but that's
Right.
Like that's never.
And that's why we're maintaining not guilty. And in order to make it through this, at some point, you're gonna have to, for a moment, just be open to understanding where you are right now. Because I understand your major push. Because I've been brought to speed. You've come up here. You've been through City Hall. You have a criminal charge that faces the possibility of 6 months in jail and a $1,000 fine. That's the most important issue that we have. Because you found out that there was a block because of this case, you're here now to get the case resolved. Everything else we can talk about at some point. Because then there are other issues, Counselor, in regard to the bond may have been put on another case. We're trying to contact that person because with your receipt, there was a forfeiture release given to you. With the information you brought back up, the forfeiture release is not present. What did you do with that other piece of paper? Do you recall? When you came up and you said the case was applied to the wrong one, it was a warrant block release given to you.
The DMV took it because it had somebody else's name. So yeah, his case on it. It's not my case.
Okay.
It's the man's who
So
took it
you,
on the paper.
so from the moment you left here and went to the BMV, you never looked down in your hand to see what you had.
No, I didn't because I gave somebody my ID. And I didn't know nothing I was doing. That's why I wrote an email stating that.
Okay.
And I didn't know what to do.
And I'm just asking you that because that's a little odd. I'm saying because you got some paper. Okay.
And the steps that everybody told me is what I did, which is come to the front.
Okay, all right. I'm just asking you when you gave your hard-earned money over and somebody put something in your hand, you're saying you never looked at it to make sure it was what you needed.
DMV the same day. And
Okay.
I flew up right back.
Okay. All right. But even still, Ms. Scott, before we even get there, we're going to deal with whether or not on this 2019 date you gave false information to the police department through a 911 call, because that's the one where you're looking at a $1,000 fine and 6 months in jail. So we're maintaining not guilty. We're going to have you come back on July 28th at 9:30 to see where we are with that case, okay? Any questions, though? I understand the other issue is out there, and we have to figure that out.
You know, I got a traffic going on with Lakewood. So I
Okay.
didn't get my license, and I can't do anything. They told me that for me to get what I need to do, I need to come down here and pay the warrant.
Okay. So when is your Lakewood case?
It's already been going on. I've been.
So when's the next time that you go to Lakewood? You just said you have to go to Lakewood. Okay, so did you catch that you're here on the 28th too? I just gave you that date, so you got to figure out, that's an issue, because you would have walked out of here with 2 dates at the same time. So you're going to Lakewood on the 28th of July. So we need to reset ours so that you don't miss our court, and we'll be right back in the same situation where you missed a court date, you have to post a bond, and all of that stuff goes on, and you have a warrant block. But if Sanders, let's set another date for Miss Scott. So what we'll do, amend that, and it'll be August 11th. All right, so what I'm gonna do, August 11th at 9:30? So what I'm gonna do, Ms. Scott, is I'm gonna place on this journal entry, so you're gonna go to the clerk's office, no arguing or debating or anything, it's just really simple. I'm gonna put here that we're gonna give you a release on this case so that you can go about the process, because you're back in court now. So I'm gonna trust, regardless of everything else, I'm gonna trust that, hey, I'm gonna release her license no matter what she's saying right now. Release the block, and you just come back when you are ready on August 11th. So, release block. And we'll see you back on that date, okay? So make sure you stop at the clerk's office to get the new release. Don't walk out of here without looking down and making sure it's in your name, all right? Okay, we'll see you soon. All right. Yes, well, give it a moment because the file is here. So as soon as the bailiff's able to take it out, they'll call your name. All right, you're welcome. Rico Griffin. Mr. Griffin, 18 CRB 00353 and 18 TRD 00694. It's a railroad crossing traffic offense. The city is dismissing that one. And then in the case ending in 353 from April 14th, obstruction of official business, resisting arrest and littering on public property. And it looks like, Madam Prosecutor, you're gonna make a record. You've amended the charge, so you've taken these 3 first-degree misdemeanors and it's gonna be 1 minor misdemeanor, correct?
Correct. This started just as a jaywalking, and then he refused to identify himself to the officer. This is an older matter, so I'm going to just reduce it down to.
Okay, and it is an older matter. So, Mr. Griffin, how do you plead to the 1 minor misdemeanor versus the 3 first-degree misdemeanors? All right, so we'll go ahead and accept that, thereby dismissing 2 of the charges. The first one, obstruction, will be amended. It's $150 plus costs. You just go to the clerk's office, you have a bond, they'll apply it, so you should be getting some money back. All right? Take care, sir. Sanseri, is it Whitington? Come on. Sanseri Whittington, come on up. Old cases 08 TRD 07838 and 09 TRD 00991. The 09 case is a stop sign, driving with a temporary license and no seatbelt. And the city is going to dismiss that entire case. And then that brings us to the 08 TRD 07838, driving with a temporary permit and a red light. You're gonna plead to the driving with a temporary permit charge, and the moving violation is gonna be amended to a no-point violation, which is called unsafe motor vehicle. Is that your understanding? All right. So you don't have a license at this point? Okay. How do you plead to the charge of driving without a valid driver's license but the temporary permit? No contest, all right. And what about the unsafe motor vehicle, which is the amended charge that carries no points? How do you plead? All right. So the unsafe motor vehicle is normally a $200 fine plus cost, but I'm gonna reduce it to $100 since you're getting both resolved. The driving without a permit, it'll be, as opposed to the $500, it'll be $200. So I'm gonna take a bit off that too. And you just go to the clerk's office at this point. They'll apply the bonds and you'll be okay. All right, take care. You're welcome. Alaric Hill, 22 CRB 00459. Mr. Hill, good morning. July 7th, alleging improper handling of a firearm. Let me see where we are. Mr. Hill, you've been in jail, what, overnight? Okay.
Actually, I've been in jail
Since the 7th. All right, let me see what's going on with this. Let me look at the complaint. All right, you're right. July 7th, 2022, alleging that you did transport a loaded firearm in your vehicle. Counselor, how are we proceeding? Is it not guilty today, Counselor?
Yes, Judge.
All right. So we're going to enter a plea of not guilty, Mr. Hill. I'm going to release you on a personal bond, giving you a chance to get out of here. And the date we're going to have him come back, Bailiff Sanders. July 25th at 9:30 is the day you'll come back, all right? So you had a question? All right. You can have a seat. We'll be releasing you today. You're welcome. Sylvia Brown, 22 CRB 00361. Ms. Brown, this is a charge of domestic violence. And we had already entered a plea of not guilty. There was a no contact order. We reset it for today. Madam Prosecutor, it looks like you're resolving this a different way for Ms. Brown.
Yes, Mr. Williams, the victim in this matter, is present. We've had extensive conversation with the attorney in this matter, as well as extensive discussions with Mr. Williams. After discussing everything and reviewing the evidence and the report and what was stated, at this time, we would move to amend the charge from domestic violence to disorderly conduct misdemeanor of the first degree. Mr. Williams requested that they do have a child together. I believe there perhaps are some mental health issues that need to be addressed. He would like to see her in counseling and things of that matter. I don't believe that at this point the relationship is going to continue, but he would like to be able to make arrangements to see his child.
Okay. So, Ms. Brown, you understand that with it being amended to disorderly conduct, that's still a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. But what's happening is you won't have a domestic violence on your record because that is an escalating offense, which means you get found guilty of one every time it goes up in penalties and the things that you have to do and the things that you can't do. So do you want to get the case resolved, still understanding that it's a first-degree misdemeanor?
Yes.
Okay. To the charge of disorderly conduct, how do you plead?
No contest.
Okay, I'm going to accept the no contest plea with the finding of guilt. And what I'm going to do is I'm going to pass it for sentencing to give us a chance to have you meet with probation, to talk with them, see where you are, see what we need to do in regard to just making sure that you don't express yourself this way in any other time that you're angry so that you don't end up in front of a court. What about the no contact order, Ms. McCullough? Are we keeping that or what are we doing in that regard? Mr. Williams, would you like to speak? So right now, you can stay right there. So right now, there's a no contact order. I understand you want to see your child, but with that, what I would suggest is that if I keep the no contact order, which I can, which keeps everybody safe, the visitation should be done formally through the other courts. I would say at this point, that way you can establish a full visitation schedule and you don't have to worry about, any hiccups in that exchange. Are you still looking to have the no contact order at this point? Okay, all right. Ms. Black, go ahead.
Your Honor, he had talked to me,
Citizen Day.
Deborah Black, this is advocate for domestic violence for the restaurant. I had spoken to him and he had said, is it possible until they resolve that in the court, maybe a third party? Because he was wondering if it could be a third party. He'd like to see his son.
Okay, is there a third party that's viable between the two of you? Who is that third party that we can identify? Go ahead.
Okay, the last time at the court date, y'all had, there's no contact with it, because you sent me to my mother's house, which is still the other side of his house. Okay.
So you say your mother's house,
She rent from him.
Okay.
It's right next door.
and that's where you're gonna be?
No, I haven't been there. I've been at my cousin's house.
Okay,
I want to keep the no contact order. I wish y'all could make it for 2 years. As far as me, I found another job. I'm working on trying to do what I need to do because my kids start school in 6 weeks. If Mr. Williams wants to see my child, he has to see me at juvenile court. And I'm just leave it like that. He's worried about my issues. We have stuff we need to deal with. But I feel safe. We're gonna start at juvenile because I feel safe. I want him to have a supervised visit with my child.
okay, all right. So what I'll do, Mr. Williams, at this point, I just want to softly caution that, hey, it's not even personal. Don't take it personal. It's just a matter of this court has limited ability to get involved with the actual visitation and exchange. So it probably is best at this point that you go down and get and establish your rights officially. That way you never have to question them. They're never, there'll never be a way that you can be denied them technically. So we'll leave it at that at this point, all right? And I'm sorry, but that's the best way to get us going at this point. Yes, Ms.
One
Brown.
more thing, because, all of our stuff is still there, me and my kids' stuff, our things, TVs, all that kind of stuff. How do I go about whenever I need something from over there, what do I do? Just call y'all and have y'all escort me?
So your items are in Mr. Williams' resident or your mother's? That's
At Mr. Williams' house.
so not in the mother's area.
No,
So
we only had clothes here.
so what I would suggest is that we make it one transaction. We figure out.
One whole day, like while he at work, I'm gonna have to take 5 people. I stayed here for 2 years. I got a whole house.
Yeah. So basically, whenever you go over there, you have to have a police escort. Now, of course, Mr. Williams, you hear that she's trying to move, years of items, and you can cooperate with that in any way that you want. Meaning, if you want to say, "Hey, I'm going to give you a whole day. I'm going to be gone," you can. Otherwise, the bottom line is though, when you come over there, you have to have a police escort. That way, that's my requirement. And Mr. Williams, with you owning the property, you can deal with that differently if you like, but you don't have to because there is a no contact order. So you will be able to get your items, but I want to make it clear that it's not I need this on Tuesday, I need this next week, I'm going over there. It has to be.
It's gonna be one day, and I'm gonna just go pack everything. I'm gonna have boxes, bags.
So Judge, it's
Yes.
just, trying to figure out strategically how it's gonna go down. Are the police gonna stay there with her all day while she packs? her
They
house?
normally don't.
Right,
They'll
so
go
how
over
is she
there.
gonna pack her house and leave?
Well, Mr. Williams, to me, it doesn't appear, and I'm speaking hopefully that Mr. Williams is going to block this anyway because he's acknowledging that she has a lot of items. My ideal, how I visualize this going, is that the police will go there to make sure that everything is okay for her to begin the process.
Okay.
Then you'll begin the process. Of course, if there's any bumps in the road, they'll be called, but they will not sit there all day. So they're not there for any security purposes, but they're there to make sure that she's able to do it, and they're aware that she's there. So if there's any problems that arise, obviously they'll be right back, and that'll be a violation on my end, from me, if the parties are not cooperating with moving her items.
I got an idea. One day, when I get the date set within the next couple of weeks, can I just come here and ask you, let you know the day, because he worked in the morning time, and I work at night, so I can do it in the daytime, like while he at work.
Well, what we can do is you're going to be dealing with probation for a moment. So when you communicate that, it'll be with our probation team. Ms. Black, go ahead.
Your Honor, it's just a suggestion. I was thinking, does he get along with her mother? Does he get along with your mother? Because I was thinking perhaps, usually what we tell victims is try to get everything, do everything decent in order. Try to get their items together and get on somewhere, because the police can't stay all day.
Right.
Where things can just be moved. So I'm wondering, do you get along with her mother? Maybe they could get together, the mother and him, so she don't think anything's been taken. And they could get everything together and put it somewhere where it'll be a clean move once she gets someone over there and they can just move it.
I was gonna suggest also that Ms. Brown make a list of what items she intends to remove. Mr. Williams actually would like to be there, and that would be a concern if she's there all day grabbing whatever she wants, to make sure that she's not grabbing something that he might have a problem with. So maybe she should make a list, get that list maybe to her mother so he can see it. So if there's an issue about something that she wants to take, it could be resolved before she ever shows up.
Right. And then the mother and him, or he and someone else, and with the mother there, assistant, can get someplace, somewhere located where they can just come in and snoop it.
Okay.
If it's on a porch or wherever.
All right, so you're understanding these suggestions, Ms. Brown. First of all, because of and what I can acknowledge this as being an important aspect, the time that you're there and that you've been there, what we're suggesting is that you make a list of the items that you know are yours that you want to remove. Because I can understand if, let's say, for instance, this relationship obviously is coming to an end. I give you the ability to go there tomorrow all day. Technically, he can come home to an empty home. That's what their concern is from that side, as opposed to us just doing it in an orderly manner. You pretty much know your items and what you want to get, correct?
Excuse me, I'm not trying to be funny or anything. If you don't have nothing in there but one bag of clubs, so everything, his table and the refrigerator refrigerator and stove. Everything else in there from every TV is mine.
Okay, so that's why I think it's important that we make the list. That
I'm
way,
talking about like paperwork, you got, income tax years of paperwork,
I
mail
think
time.
paperwork would be an issue.
Yeah.
With the bigger items that cost and.
yeah, I think it's more so, like you said, the TVs and things like that. So let's
Dressers, my kids, stuff like that. My son a moped, got a 4-wheeler, $500. My daughter got a moped.
Okay.
in there. Plenty of containers, toys, hoses.
still next. Let's do that. Let's make this list of the items that you know that you're going to remove. What's this August date for me? But what about the date to meet probation? Why need both? I mean, they got to meet them to be. I want them to get pre-sentence investigation and then come back to me. Okay, that's cool. So what I'm going to do is this. I'm going to set a date for you to meet with probation. Anyway, that we're going to deal with that in regard to anger management and all those things. That's one. And how long do you think it'll take you to itemize what you need to take out of the house? Is it maybe a day? You can probably do that.
To get everything out.
No, to itemize, to make a list of what you need. That way we can make sure everybody gets a chance to look at this list. I'm sorry?
I say yes, I can.
Okay.
If I get enough raise before I pay rent.
So what everybody, Miss Black, what we're expecting at this point, Miss McCullough, is for Miss Brown to create a list, right? And then we're gonna make that list available for Mr. Williams, or are we asking her to give it to Mr. Williams' mom? Let's get clear on that, because this is the first time in all of these years that I've had to go into this much detail for items to be separated. And it's haven't been a long time, but it's been long. Go ahead.
I'm just saying this because I just brought this. This stuff is very new.
Mm-hmm.
In the bathroom, the medicine cabinet, and I got my receipts from Home Depot. The medicine cabinet, glass medicine cabinet, $300. I want mine.
Is it attached to the wall?
No, it's already out on the floor. And
Yeah, see, that's why we need a list, because that's exactly
I got my receipts.
what we're dealing with. So here's the deal too. If it's attached to the wall, okay, all right. Mr. Williams, go ahead.
I had a medicine, a cabinet on my wall in my bathroom until she tore it down.
Okay.
But she gonna bought another one. Now she want that. She want
Okay.
it back. If you took mine down though, I have one when she came here. And I'm just constantly with it.
Okay. So this is what I'm going to do, I think, because we're running up on what's going to be an issue. So here's the deal. In regard to the disorderly conduct amended from domestic violence, I'm accepting your plea, no contest, the finding of guilt. There won't be any jail time opposed. I'm going to have you on probation so we can deal with anger management and whatever else we need to figure out for you. The date we're going to have you meet with probation will be Wednesday, the 13th, which is this week at 2 o'clock, all right? I'm going to put here, Mr. Medley, that we're looking at anger management, and after, I was going to do a pass for sentencing, but I'm just going to go ahead and get this resolved. Anger management, and then, we'll determine what's necessary from there. 2 o'clock on Wednesday.
How long,
I'm going to put here 2 years. I'm going to put here a $200 fine.
They have her give me my keys and my car. She won't give me my car, she needs my spare keys.
All right, and then this is what I'm going to do. Hold on one second. This is what I'm going to do. I'm going to set a separate date for the two of you, because it sounds like we have a whole lot of items to deal with. Car, she's talking paperwork, mopeds, medicine cabinets. I'm going to set a date where we can come back, and I'm going to actually give you two the opportunity so we can you can present your list, we can figure this out, and we can nail it down. But as of right now, the only items I want you to take are those that are necessary for your immediate survival: clothes, medicine, stuff like that. Because all these other items, I think we need to come back and get this resolved, because I don't want any arguing or anything at the house, because obviously there's a dispute on some of these things and we need to get it ironed out. Yes, sir.
I just, was wondering if I had a key, give me my spare key, my car, cause my car come missing.
Well, we'll do that when we come back. Do you have a spare key to his car? All right. So again, that's something we're gonna have to bring in. If your car goes missing, that's theft of a vehicle. So those are things. So all I can do at this stage is say, hey, Miss Brown, if you have the spare key to his car, give him the spare key to his car. But her first statement to me was that she doesn't have it. So that's why I'm thinking some of these things we're gonna have to take some time and really iron it out. You do not have a spare key to his car.
No, I don't even want my car, it's in his name, and I put $10,000 into the car, I don't even want it.
Okay, those are civil issues that if you put that kind of money in, you can work out on that later date, so let's not put statements like that on the record. Just yet.
Otherwise, it'll be for little. She said on the property. Hold on, Mr. Williams. Hold on 1 second. Because I got to give you the date to come back so we can figure out all these property items. Because we haven't resolved that at all. Something else, just in a bit, just light. So we're not here to 7 o'clock. Thursday. So what I'm gonna do, Mr. Williams, she's gonna get just her personal items at this point. I'm gonna set a date for everybody to come back. I'm gonna need an itemized list from you. We can sit here, we can spend some time trying to figure this out, because what I want is for this domestic violence that's amended to disorderly conduct to not blow up into another issue. And it sounds like it's already where an issue can occur. So I'm gonna do what I can. I normally don't even do this. I'm gonna set a whole nother date where we can spend some time and figure out how we can come to an agreement on who has what, how we're gonna get it out of there and all that stuff. All right? I'm sorry?
I paid for the four-wheeler.
Yeah, but that's why we're gonna figure this all out. And hold on 1 second. What date?
It's for your son, it's for your child.
All right. This is what I'm gonna do. I'm gonna give us 2 weeks to get everything together. The 28th, which is a Thursday at 3 o'clock, I'm gonna have you come back. Bring as many receipts, proof, all the stuff, because on that date, my goal is to be able to say, what's going where. And I'm doing that as a courtesy. And if at some point you don't agree with what goes on in that regard, there's a whole, as counsel said, there's a whole another way you can take it in regard to civil actions where you're suing each other for items and things like that. But I'm just trying to have a peaceful division of property for purposes of the no contact. So some of these issues that you may bring, I may not even address. For instance, if you bought something for her son and you want it back, all those things, I may not even address those. What I'm gonna try to address, and I'm gonna make it very clear, is the things that she's gonna move that are probably clearly hers, and those that are clearly not hers, so we can separate and move on. If there's any gray areas, that may be cause for a civil action. All right. If there are things that you like, for instance, the whole argument about the cabinet was broken, so you owe me for that. All of that stuff, that's something we can bring up in another form if we need to. The two of you are not married, correct? All right. How long have you lived together? 10 years. Okay. All right. So did you give Mr. Williams a date when he's coming back? All right. So right now, Ms. Brown, the understanding is when you leave here, the only thing you can get from the home with police escort is any personal items that you need until we come back on the 28th.
What days at 9:30?
3 o'clock.
3 o'clock, thank you.
And remember, for this case, the day you're meeting with probation is this Wednesday at 2 p.m. But before you even walk out the courtroom, Mr. Williams is going to leave. You're going to see Mr. Medley in a moment. So you're going to have a seat and he's going to come talk to you. All right, everybody understand? All right, thank you. All right. Aaliyah Fisher. (22 CRA 00458) is from July 8th, alleging improper transportation of a firearm and failing to comply with an officer's order. Failing to comply with an officer's order is a felony of the third degree where you're looking at 9 to 36 months in prison and a $10,000 fine, because they're saying that on or about July 7th, you operated a motor vehicle at speeds upwards of 100 miles per hour in the area of Euclid and Shaw to elude police officers. Then there's improper transportation of a firearm, a felony of the fourth degree, 6 to 18 months, because they're saying on July 7th, you were the driver of a motor vehicle with a firearm in the car under the front passenger seat, and you're 20 years old.
Don't make any sense.
Yeah, I think the bigger issue is going 100 miles per hour through the city of East Cleveland. That charge, I hope that would be the one that shocked you. But either way, these are felonies, which means the case cannot be handled in this particular city, but you do have a right to a probable cause hearing. And I'm going to talk with the prosecutor and defense attorney in a moment to see where we're going in that regard. We have misdemeanor charges for driving under suspension, and specifically stating that it's an OVI suspension. An OVI suspension means that at some point you were given a suspension based on driving under the influence, which means if you drove under that suspension, it's a mandatory jail time or term. And this is alleging that that occurred on or about July 8th. Then there's failing to comply with an officer's order, 22 TRD 01684. And again, that alleges that you did not stop your vehicle in order to do so. Detective, we have the failure to comply, which seems to relate to the felony, correct?
Yes, sir. Everything's going down.
Even the driving under the OVI suspension?
Yes, sir.
All right, so the first thing, Ms. Fisher, it looks like all the cases will be sent to the county. That way you're not dealing with East Cleveland on the misdemeanors and the county in regard to the felonies. Everything will be kept together, so give me a second for that. Man, what the heck?
Yeah, I gotta see if this one.
All right. Counselor, in regard to the felonies, how are we proceeding?
Judge, I had an opportunity to speak with my client. She's prepared to waive the preliminary hearing, asked that the case be sent downtown, and we would respectfully request a reasonable bond. She's indicated she could probably come up with around a $500 bond. I would ask that the court consider that, 5,000, 10%.
Detective, the bond request.
25,000 surety, Your Honor.
All right. Okay, so Ms. Fisher and everybody else, if there are any other felonies, what happens in regard to your felonies is that I set a bond that goes with you until Friday. Your court date downtown is Friday, the 12th floor of the Justice Center at 9:45. They're going to give you a reminder so you won't miss court. You have a bond that'll be set here. That means you can get out from East Cleveland and appear at the county. Or if you cannot make the bond that I set, you'll be transferred to the county. The one thing I always mention is the bond that I set from here is the bond until Friday, because on Friday, that judge who's going to assign the case to a judge who will have it from beginning to end can give you a personal bond. If you recall, I gave a personal bond to that young man because that's my case. He'll be in front of me the entire time. The judge downtown can give you the same consideration. I don't normally give bonds as low as personal bonds on felonies, but that can happen for you downtown. The detective is asking that the bond stay at $25,000, 10% of surety, which means it would be $2,500 for you to get out. How long has she been in jail?
Ever since the 8th July. She's 20 years old, right? She has no,
I'm sorry?
cycle arrest record.
19? Okay, go
So,
ahead.
10% would be good.
All right. Was there any other person in the car?
Yes, she has a co-defendant.
Okay.
Can I say something else, Sean?
Counsel, do you mind?
What are you gonna talk?
Yeah, she don't want you to say anything that could jeopardize your case.
The job suspension,
Oh, I would not talk about that.
Yeah, because as of right now, you're not guilty of that. So, okay. So the only thing, Ms. Fisher, and I guess I'm gonna have the same. Ms. Fisher was driving.
Yes.
The only reason that I'm sitting here moving and twisting and turning is because normally, and detective knows this, normally my bonds for failure to comply with the officer's order start at $50,000 and go up depending upon what was going on. Why? Because, you know, I take it really seriously, the danger of traveling that fast, not only to other people, but to you. You know, the fact that if you hit a bump or hit a curb or something, you could be dead. And even more so, regardless of the reason that you were running, and it's not my business because it's not my case, there's no way that you woke up that morning thinking to yourself, I don't mind getting in a car and hurting somebody else because I'm driving too fast or killing somebody else. But that's what happens when people fail to comply, which is why I set the bonds high, because I take it very seriously. So what I'll do, Ms. Fisher, is this. The bond is normally $50,000 and up. What I'm gonna do is I'm gonna keep it at the $25,000, 10% of surety. So I'm not gonna raise the bond, but I'm not gonna lower it. But keep in mind, that's my position on the bond. Like I said, when you get downtown, that judge may look at it and say, you know what, Ms. Fisher's 19 years old. She's never done anything before. That judge probably doesn't live in the city of East Cleveland, so never have to worry about, you know, what happened or doesn't happen. And they may give you a personal bond, to be honest with you. So my bond is I'm gonna go ahead and keep it at the $25,000, 10%, but it can be lowered, and it probably will be when you get to the county, okay?
will I be going to the county today?
Yes, you will.
Yes. All right, you can have a seat. 22 CRA 00457. Ms. Houghton, is it Nashyla? Come on up. Nashyla, come on up.
That's the vote.
Okay, thank you. So the co-defendant here. Good morning. Carrying a concealed weapon and improper transportation of a firearm. They are alleging that the carrying concealed weapon occurred on or about July 7th, where you were a front seat passenger in a motor vehicle where a gun was located from under the passenger seat. The detectives are requesting that the gun be forfeited, but that'll happen at the county level. It's a felony of the 4th degree where you're looking at 6 to 18 months and a $5,000 fine. And then there's the felony of the 4th degree, same possible penalty, 6 to 18 months and a $5,000 fine, because they're saying that on July 7th, you were the front seat passenger in the motor vehicle where the gun was located, and it was a vehicle. Those are the two felony charges. And then there are misdemeanor charges of not having a seatbelt on in 22 TRD 01675 and consumption of alcohol in the motor vehicle in 22 CRB 00452. Detective, are all the cases going to the county?
Yes, sir, everything's going to count.
So Ms. Houghton, the same situation. Even though the traffic offenses would normally stay here, we're just going to keep everything together so you're not juggling between two different courts. You understand that? Counsel, in regard to the preliminary hearing, how are we proceeding?
Judge, she's prepared to waive the freedom. She indicated to me that she does not have any money for a bond, so she's respectfully requesting a personal bond.
All right. Detective, it looks like your bond request is higher on this particular
Yes,
case?
sir, Your Honor, because she has a 3-cycle arrest record, no conviction as of yet, but she is under indictment from another city.
All right.
We're requesting 50,000 shooting.
Are you aware that you have the other case pending or some other issue pending? Or are you just aware of it? I just want to know yes or no. Okay. All right. So the bond won't be a personal bond because, as I mentioned, I don't do the personal bonds on the felonies at this point, especially these types. Waiving the preliminary hearing. Keep in mind you're still not guilty, so you don't worry about that. It's just a matter of how the case gets down to the county. So really quickly, your court date is going to be Friday. All right. I'm going to reduce the bond to the 25,000, 10% of surety. I'm not going to hold against you whatever else is going on. I'm going to leave it the same that I would make as if this was just you appearing before me. But I will say this real quick. You know, I don't know why today I'm at a loss for words. I don't know, maybe because it was a long weekend. But when I see you two very young ladies in front of me, it really kind of breaks my heart to see these charges and see what you're, accused of doing. The driving the vehicle, that being in the vehicle that fast, the vehicle having a gun in it when you're underage and not allowed to have a gun, and the, allegation that you're drinking. You ladies have the opportunity to do whatever it is in this entire world that you want to do. But this start is gonna hold you up and maybe even push you backwards. I mean, really, no matter what it is that's causing you to get involved in this situation or in the environment, you gotta think about it and check it as soon as you can, because you still can recover. These are charges that you're gonna have to deal with, but it's not the end of your life. But I don't want this to become the cycle in your life where you're dealing with these types of situations. And I don't want you to ever think, I don't know what was going on in the mind because you're not guilty, that it's fun to run from police, it's dangerous to run from police. We see across this country, people move in front of police and they get shot and killed, let alone driving 100 miles per hour. I mean, so this is dangerous. And the other thing I want to mention, I don't know what was going on with the gun in the car, but that's not even saying the two of you shouldn't be friends. You could be best friends, cousins, whatever, but you gotta be careful who you're rolling with if weapons are in the car, because as you see, you both are charged. 9 times out of 10, I don't know, it's rare, but y'all didn't go together. You put 50 on it, I put 50 on it, buy this gun together, walk around holding it together. It belongs to somebody, but everybody's charged, because when you get in the car and somebody has a weapon or drugs or any of that, everybody's going down. So, I mean, you just got to start thinking more importantly about your future and what's important to you and how you can actually change the world in a positive way as long as you stop making these mistakes. So, and I don't even know what else is going on, but to even to hear that, how old are you, 19? 18, and have another issue in another city. But again, regardless of whatever that is, I'm saying that when you turn today, you can say, I'm done with that. It was fun. It wasn't fun. I'm moving in a different direction because I want to be X, Y, and Z. And you can. But I mean, I want you to think seriously about it, because, and then what happens, and the last thing I'm going to say is, I'll leave out of here and people will say, Judge, you crazy because some of these young ladies are doing more crimes than the young men. And I don't believe that. I mean, it could be true, but I don't want to believe that. When I look at you two, I don't see that. I see my little daughter, your age. She's younger than you, but I see her standing in front of me, and I don't want to see that, all right? So it's not guilty right now. The bond is what the bond is. Your court date is Friday, and the next time I see you, I want it to be, I want you to say, hey, Judge Dawson, guess what? I'm moving past that. This is what I'm doing. This is what I'm doing in my future, all right? And even if you have trouble getting there, we can help you get there. You have a question? Yes. 25,000 as opposed to 50. They wanted it to be 50. I'm gonna make it the exact same. 25,000, 10% of surety, which means a bail bondsman can help you get out and you won't have to pay all of that. Or 10% of the 25,000 is 2,500. But based on both of you being very young and not having a much of a criminal record, even though you got some other stuff pending, downtown, that judge may give you a personal bond, to be honest with you. It's very well possible. All right? You can have a seat. George Parnell. 22 CRB 00284. The charge is assault. From May 16th. We had set this matter for a trial. The trial was scheduled to go forward today. Madam Prosecutor, how are we proceeding?
Your Honor, the victim in this matter is facing felony charges downtown, so I checked the docket to see what was going on. It seems that he just received a personal bond this past Friday, so it's likely that he never even knew about the subpoena for this. So in light of that, we would respectfully ask for one last continuance.
So what I'm going to do, Mr. Purnell, I normally give each side one chance to ask for a continuance based on what they're explaining to me. I'll give him a chance to see if he gets here. And if not, I'll be really open to what the defense attorney will probably be asking me to do at that time. But we will reset it to give the city a chance to get her witness present. What date, Mayor Sanders? August 11th? August 11th at 1:30 will be the new date. All right, we'll give you 1:30, and we'll give you the reminder. Yes, on August 11th. That's a Thursday. All right, we'll see you back then. Javon Lewis, 22 CRB 00345, domestic violence charge that we had set for a trial. All right, so Madam Prosecutor, how are we proceeding today?
I do not believe Ms. Stevens is present. She was subpoenaed for today. I haven't had any personal contact with her, but I think she has spoken to at least our office and Ms. Johnson as well.
Yeah.
So we would respectfully ask for one final continuance.
So Judge, I would respectfully request that the case be dismissed. She was served a subpoena. This is unlike the last case in that, that gentleman likely did not receive a subpoena. So I would ask that the case, be dismissed without prejudice, and if she shows up, they can refile.
All right. Yeah. So, Mr. Lewis, what's happening is your attorney is making an objection, which is the right thing for the attorney to do. But based on the information I have, and with it being just a June case that it started, I am going to give them one opportunity to get this. And when I say one, I say that lightly. Don't hold me to it. The bottom line is that they allege that you committed domestic violence and that maybe there was a gun involved. You're not guilty of any of that. But I do want to give the prosecutor a chance to get the victim present, all right? So the new date we're going to set is going to be August 18th at 1:30, and I do note that there was an objection by your defense attorney, okay? That's overruled, all right? So we'll see you back on that date.
1:30, Your Honor.
Yes.
Thank you.
Robert Long, 20 CRB 00035, violation of a temporary protection order. The complaint is alleging that on or about the 25th day of July in 2019, you did violate the terms of a protection order issued by this particular court. All right. So he was arrested on a warrant for this?
Correct.
Okay. How long have you been in jail?
What, here?
Yeah.
66.
Okay, so you were transferred from another
Yes.
court?
No, I actually was, I was transferred here from, with, University of Turkey.
How long were you in their custody?
Not over 30 minutes.
All right. Are you working currently?
July 6th was my first day on the job and I got arrested.
Okay. Where you living? Do you have stable residence right now?
Yes.
Okay. So what I'm going to do, Mr. Long, is maintain not guilty at this point on these and give you a chance to come back so you can deal with these issues. But you got to definitely come back. I'm going to, take for granted or hope that you didn't realize that you had to come to court on this other situation. But I'm going to trust you that you're going to come back. Okay, so what I'm being reminded of though, on probation, you never reported to probation on that old case, is that correct?
I was never told I was on probation.
All right, you don't recall. Yeah, because I have here, when I saw you, so today is July 11th, right? I saw you July 25th in 2019. There was a no contest plea, a guilty finding, $200 fine, 180 days in jail. You went to jail from me. Okay, and then when you came back, you didn't come to probation. Is that right? What happened when you got out of jail? You just continue to live your life?
I was relieved January 1st, 2020 or whatnot. They did a worldwide check on me.
And you didn't recall? Okay, but you didn't come here, right?
No, I didn't come here.
Okay. Did you read a letter? Why when you was supposed to report? Did it say that in the letter?
No, he wanted to get out.
Oh, yeah. I said, oh, yeah. Okay.
This was 1921.
All right, so this is what I'm gonna do. We're gonna figure out what's going on with this case, but here's the thing. I'm gonna give you consideration. How old are you now?
26.
26, all right. And who are you living with now? Are you living with the same person that we've been dealing with in this case? You might as well be honest with me at this
No,
point.
no, my mother-in-law, yes.
Your mother-in-law. And the young lady lives there?
Yes.
All right. Is that correct?
Yeah, she's in court, Your
The young lady's in court. You're the young. So, ma'am, your name is, what's your name?
Honor.
Ramsey, okay. So the two of you are living together now? Are the two of you getting along okay right now? All right, so here's the deal. Mr. Long, the fact that you and Miss Ramsey are getting along right now doesn't negate anything that we have to deal with. What it does, it just gives me a little comfort with how I'm going to handle the case right now. We still got to figure out what was happening because back in 2019, you know, you went to jail. I told you not to contact her. You did, but what I'm going to take into account is that when all of this stuff happens and you're standing in front of a judge who doesn't really know you as well as the two of you know each other, and you don't have emotions for me like you have emotions for her, you're probably not listening to everything that I'm telling you perfectly. So though you wrote me a letter about getting out early, maybe it didn't calculate, well, I better go see that judge when I get out. You know, even though they run a warrant and all this, see if there's a check, you got to remember in your mind, you got to force yourself to remember, Judge Dawson wanted to see me when I got out. That was the problem with the warrant. And then there was still my order that you couldn't even contact her. So all of that to say, we're going to deal with that later because I'm going to let you out of jail right now and have you a date for you to come back. Not negating what happened, but we're going to move forward from this point, all right? So July 28th at 1:30 is when you're going to come back, all right? And at this point, Ms. Ramsey, you have no issue with contact at this point? All right. Ms. Black, has Ms. Ramsey worked with your group at all or been in contact with you since any of this has been going on?
Your Honor, you need to talk to her.
Hold on one second. Go ahead.
Everybody can talk, you tell me that. And she's starting group. Because I told her whatever happens, you're gonna have him do something, even if he goes to jail or not, he's gonna do something. And there's no reason for him to do anything if she don't do anything.
Right.
Because they both pay a part. And she goes up and down with these emotions, her mother gets involved, she said she'll come.
Okay, so you're gonna work with Ms. Black.
She's gonna start that now.
Okay, and the reason we say that is because again, you know, Mr. Long, we're gonna deal with you, but you've served time. You know, you've dealt with some things. We're gonna build you up. You know, but at the same time, you know, like Ms. Black said, is you know there are two parts in many of these situations. So we're not gonna just work on you and nobody else is getting any better. You know what I'm saying? Because we want you two to, if you're gonna be together so that you don't have courts involved. You know, most relationships don't need me involved in them, and I don't even want to be involved in them. So we're gonna work with you. So I say all that to say I'm gonna go ahead and dissolve the no contact at this point because they are contacting each other. So, but I expect there to be no arguing, no fighting, and all that stuff. Okay. So you'll be released today, Mr. Long. July 28th at 1:30 is when I'll see you back, and you're gonna be working with Ms. Black. All right. You can have a seat. You're welcome. So I'm gonna make a note. Let me hold this. Good. Personal monitor? is it?
Which one was this?
Thank you. All right, what do we have left? Christopher Gilmore. What was this? Okay, so we're here. Remember, we had 22 CRB 00435. That was the case we had the trial on, right? Do we have we don't have a trial, J.E.? Yes. You said this is the one we were where is it? Is this the actual case? Is this the file? What do we got? And then we have 22 CRB 00434. That's a new charge of violating a temporary protection order.
Oh, this is the one too. Oh, let me go with the other one. Oh, that's a new one. I didn't know it was new.
Okay. I'm sorry. Let me be clear. The 22 CRB 00435 and 22 CRB 00434 are new charges that the city are bringing on domestic violence. They're saying that on June 30th, you caused or attempted to cause physical harm to a Miss Crute by punching her in the face with a closed fist. This is on June 30th. Then they're saying on June 30th, you violated my temporary protection order because you left the court and immediately had contact with the victim and blocked her vehicle. And that was June 30th, and you've been in jail since that time. And we also have an old case that we had a trial on that we haven't made a decision, haven't done a verdict on yet. So, Counselor, we're maintaining not guilty on these new charges?
That's correct, Judge.
So, Mr. Gilmore, I'm a little baffled because honestly, I didn't expect to see the domestic violence. I knew there was an issue in regard to the violation of no contact order, but there was more to it, obviously, that you're
There
alleging.
were allegations that he punched her in the face.
Okay. Can the two of you approach really quickly? Is that her in the back?
I don't know.
Is that
what
her in the
is.
back? Yeah, come on up. Is that her in the back? Is that something on her eye? Is that a mark on her eye? Or in the back?
You know what?
Are there any visible?
I didn't stare down because I didn't, we had a trial. I didn't want to feel
Right.
uncomfortable.
I mean, I don't know. So what's going on here? I mean, like, how can I make sure she's
If you
safe?
remember, back when this thing first started.
I know it's about a car, right?
Right, and it's about this stupid car.
Yeah.
I mean, but what I'm
Because
trying
that was the very first violation.
so what I'm trying to figure out is this, counselor, is I was leaning toward a disorderly conduct, right? But now I'm just concerned if she's safe with him in the community. Like, I'm really concerned at this
You know
point.
what I'm saying? We're not TikTok. Is the record on?
No, are you on? Either way. I mean,
You know what I'm thinking? I was thinking about this on the way in today, and I obviously can't tell you what to do, what I
Yeah.
did to judge, but this is what I'm thinking.
She's safe.
I'm thinking that trial was a not guilty.
all right, that's what
He is never in life gonna get past this protection order violation. And he gets
but
found
but my
guilty on
problem with that
The
is
car right now was impounded this weekend.
it was what?
impounded.
The car that he was driving was probably impounded. She said the car that she has
Is impounded.
How did it get? How did it get?
I don't know.
Probably left it on the street somewhere.
I think he's never getting around the protection order.
Yeah.
Even if he has to try on the DVDs, which I don't think would happen, whoever it's with, he's never getting around that protection order.
Right.
I think the evidence on the DB was weak. I think that's a not guilty, and I think he's gonna be found convicted of the protection order violation, and I don't know the accusations of the DB, but there's no getting around that.
Yeah, that's gonna be it. I'm just trying to
That's gonna
figure out
be an M1.
what do I do in regard to a bond for this man? Is it safe to let him out?
Put a GPS on him.
I'm sorry.
GPS. What, you guys do that?
I mean, I guess probation could.
They used to do it.
Huh?
I think
Does he,
so.
at his expense, because usually it's
Yeah,
a
it was
defendant's expense.
Yeah, Walker used to do it in defendants.
Because see, the thing is, it's technically a 12-day facility, so I can't hold him indefinitely, or you know what I mean. But because he had the easy, this is gonna be easy, but he's pleading not guilty today, so you're not pleading guilty. If you plead guilty to the temporary, to the violation, then I can ship him today.
If he did?
But understanding that I'm gonna probably give him jail time
I know.
today.
Oh, I
Yeah.
know that.
Okay. Cool. All right. So let's see.
What? Oh, thank you.
Interesting. Thank you.
Yeah.
That's true. 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 I wonder does this mute thing really work? I have to figure that out. Oh, this is it. This is the whole. All right, so maybe I can do Robert Law. No, come on up.
We could do that. Okay, I think we have a resolution, George.
Okay. Give me 1 second. All right, that's that. I was holding that. All right, we're ready?
We have a change of plea, Judge.
Okay. You want to recognize? Yes. All right, we're going to go back on the record. You can stay there, Mr. Gilmore, if you want. So what we have in regard to new charges is 22 CRB 00435, the allegation of domestic violence that on or about June 30th, you punched the alleged victim in the face. Then we have 22 CRB 00434, violation of a protection order, June 30th, after leaving the court under the protection order or the no contact order, you immediately contacted the victim and blocked her vehicle with your vehicle in the parking lot across the street from the court. All right, Counselor, how are we proceeding today?
Thank you, Your Honor. May it please the court. Judge, I had an opportunity to speak with Mr. Gilmore regarding the 2 charges. I understand the state has proposed an offer today that I gave to him. It was to enter a plea to 1 count of a protection order violation, misdemeanor in the 1st degree, and in exchange for that, the state would dismiss the new charge of domestic violence. I've had an opportunity to speak with Mr. Gilmore about it. And in fact, Judge, he knows his rights to go to trial. We just held a trial together. I understand he's prepared to waive those rights in order to enter a no contest plea to this 1 count of protection order violation. Is that right, Mr. Gilmore?
All right.
Has anybody forced you or promised you anything in exchange for your plea today? Okay.
All right. So is that correct, Madam Prosecutor? You are dismissing the domestic violence charge?
Correct.
All right. Okay, no. All right, so what I'll do is I'll accept the no contest plea with the finding of guilt on violation of the protection order. It'll be 180 days in jail.
Oh, Judge, can we be heard?
Yes, go ahead. Go ahead. I'll give you that chance before I even say anything else. I haven't. Go ahead.
So Judge, Mr. Gilmore, obviously, there are issues in the relationship with the alleged victim, and in this instance, it was regarding the vehicle, which I know the court was outstanding. I think the purpose of the encounter with the vehicle was to get it back. Of course, subsequently, the alleged victim came outside, which forced contact upon them. That being said, Judge, I've explained to Mr. Gilmore that no contact means, no contact. I mean, she may not have been out there at that moment, but clearly she drove here in that car. And I think he understands that. I've explained to him his rights with regard to a civil replevin action to obtain the vehicle back, as well as going through the avenues of the court to get the vehicle back. But so I think he accepts responsibility by entering the no contest plea, but certainly the purpose, I'm not sure, was to have contact with her, was really to get his vehicle back, which subsequently resulted in contact to which he takes responsibility.
Thank you.
Right?
And Madam Prosecutor, I see out my purview the victim raising her hand. Is there something that the city would like to present or that she would like to be heard on?
She didn't get out. I don't believe
Yeah,
she really spoke out.
go ahead, stand up and come on up.
You know, Coach,
Yes. State your name for the record.
Sophia Cruz.
Okay.
I just want to say that when I was here previously on the 30th, I was here June 6th. And on June 6th, I stated about my car, the 2011 Ford Fusion. I stated that I was here to receive my keys from Mr. Gilmore, my house keys and my keys to my vehicle. I said that he had these keys and he said that it's his car. I made it clear that I paid for the car before. I put it in his name. And you, Judge, you said, okay, give her her keys. If you have her keys, to give me my keys. So then I received a set of keys from up there, from the officers, and gave it to me out of his property due to what you said. But Mr. Gilmore has an additional set of my keys. It's not his car at all. I paid for that car. That's my car. The only reason that he is trying to get the car or want the car because he's mad at me. He's done this in the past before when I say, well, you can just leave. He said, I'm taking my car with me. I said, come on now, you know that ain't your car. So when I let him back in the house, when he's claiming to love me, I say, can you sign my car out of your name into mine? He's never done that. Even when he got incarcerated or arrested, I called his mother and I said, I asked your son to buy his baby some diapers. He cussed me out. He said he had to pay bail and the car out, and it's my fault. And I need to take responsibility for our child because he needs to regain himself from the money that he lost. So I say to his mom, because I still have her key to the car that he was driving. the key. I said, you want your key? Because it's in her name that he drives. I said, can you tell your son to sign my car out of his name and to give me my keys? Because I know she wanted the key to the 2021 and she's paying the note for it. She don't advise her son, but I'm here just to say that Christopher needs mental health counseling. He needs drug treatment counseling. He also needs parenting classes. I do not want any contact with him. I don't want him around me. I'm scared to be around him. I have this child, and I want him to be a part of his child's life. It's his only son, but he can't be because of his condition that he will not admit to. He's obviously on drugs because who would attack someone outside the courtroom on the case that we had? I'm not happy with dismissing the domestic violence or the assault. I'm not happy with it because I've been assaulted several times. I was punched in the eye outside the courthouse in that parking lot. He approached me and my daughter. I left out of here. You saw me leave fast because I wanted to get to my car and leave before he came out. We got caught at the light. It was buses passing. My daughter looked back. She said, Mommy, here come Chris. We moved all the way down the street, out of the crosswalk, away from it. Mr. Gilmore came outside, called me bitches, saying, you want to come to court? I'm going to take my car. I screamed, fuck you, crackhead. That's my car. So I don't want to engage with him. I let him cross the street. He went toward my car. We still got caught at the light, cars passing. I got across the street. He come toward me. My daughter screaming, get away from my mommy. Leave my mommy alone. She's screaming, crying. He flinched at both of us. So I said, I'm ready to fight him then because he has hit my daughter before. He's put his hands on her when he was choking me. And she said, get off my mommy. And he pushed her across the room. He was arrested for that. He took my money on that day. And I called, just like I called his PO, I called the judge. I called in Zoom court and say, I don't want him to do that time because I fear it was like 3 years or whatever. And that judge said, Ms. Crew, I strongly disadvise against that. She wanted him to stay and do his time. And I didn't. And he got out and he got a job for the first time. And I supported him before that. And the PO ordered him to drug treatment. He, upon himself, got counseling for himself. Mr. Gilmore is a narcissist. I believe that he was, the counselor was falling into his lies because he was not telling her the truth. So I say, listening to these counseling occasions that he would have with her, I said, Dad, how is that therapy? How is that counseling? How is that working if you're lying to her? She's believing you. He had the woman come to my house. And I said, he told me. She came over. I said, what? And then he started yelling at me. So I learned that when he yells, he's lying. He said, I told you. No, you didn't. You didn't tell me she was coming out of my house. Why was she here? She wanted to explain coronavirus. I said, well, where's your license for real? Because he been lying to you the whole time. And I want to know why she was in my house for real. So I think, because I read, a narcissist will learn things from the therapist and use them against court people he heard. And I don't want him around me without mental help. He's obviously has something wrong with him. That's my car, Judge. And he want to get out of here and try to take it from me. This day, whenever he get out. If he get a wheel to in jail, he want to try to take my car. And that's not right, Judge.
All right.
Thank you.
Ms. Crew, how old are you?
I just turned 40 on Saturday.
40. All right. Okay, thank you. And Ms. Crew, as you're going back to your seat, I do want to mention that the woman that's to your left, Ms. Black, has been working in this area for many, many years. And she has contacts and those people and resources where when we go through these situations, everybody needs help. You know, the victims need help, the offenders need help. I mean, other than the mass confusion about the car, I mean, it's just everything just sounds so very toxic.
It is.
And-
I signed up for counseling myself.
And I want to say this too.
She's agreed to come.
Yeah, please work with her, because just as much time as you put in, which is important, to research what a narcissist is and all that, the same effort has to be put in for you to get to a situation where you don't even deal with a person if everything that you said is true, that brings that type of drama to your life. You know,
That's what
so
I said. I signed up for counseling myself.
Okay.
Before her.
that's important. All right.
It's very important.
Okay, so you can have a seat. So go ahead, Council.
Did we have a ruling on the Friday, last week or the week before, whatever, in case that?
Well, what I'm gonna do is so what I'm gonna do on the trial case to get everything concluded, 22 CRB 00236, after hearing the evidence presented, I'm gonna find a finding of guilt on lesser charge. I believe it's a lesser included charge. I mean, you know, you can appeal that if you would like, of disorderly conduct, meaning that I'm not finding that there was domestic violence, but there was something that went on in that regard that was disorderly. The conduct was disorderly on that evening in regard to the arguing and or fighting in front of this young lady, not Miss Crute, but even the daughter at 4:30 in the morning. All of that to me there was something going on that was definitely at the very least disorderly. So that's going to be my finding on that. The finding or the agreement on the temporary protection order violation is a finding of guilt on the no contest plea. So whatever I do, I'm going to run them concurrently. On the disorderly conduct, there'll be a $0 fine. On the violation of the temporary protection order, there will be a $1,000 fine, but I'm going to suspend $800 of the fine because it's not even about the fine. Mr. Gilmore, my issue with the violation of protection order is that I believe I was very clear from the very beginning. A lot of situations happen with people in this court, and my whole goal is to figure out how to have parties walk away from this court somehow complete, whether it's getting some treatment or, you know, working out the relationship or separating. My goal is not to send you to jail. That's why I gave you a bond. But then when I say that there's a no contact order, and I know I explained this to you, that is one of the most serious orders that I give, because I'm trusting you in the community. I'm putting my faith in you that you're not going to cause any issues. You brought up the issue of the car from day one. And my memory of that is I said, don't worry about that at this point. There's a way to deal with it, but I don't want you going to jail over a car. I'm almost certain I even said those terms because I can tell that this car was so important to you that I could have sensed that you were going to violate my order over this car. And I said, don't let that be the way you go to jail over some car. You want to go ahead? Yeah.
The only reason the car is an issue to me, in all honesty,
Okay.
is because she uses that vehicle to come to my mom's house.
Okay.
She used that vehicle to come to my job, and basically harassing me, stalking me since the entire relationship. I've been financially responsible for this woman for the entirety of our relationship. I've been working since day one, since the first day I met her.
And you feel a car is going to change all of those issues?
Yes, that car will prevent her from being able to come around me, because I've been trying to break away from her since the first day I met her. I broke up with her 2 months after I met her. She's been stalking me and coming to every place I work. She called. I've got previous employers I can call. They can vouch. I have previous friends. I have friends who can vouch that she's come to their houses and stalked out in front of their houses. My mom can vouch that she came to her house and stalked out in front of her house. So I feel if I remove that car, that will prevent her from being able to continue doing with that type of.
Well, and I'm not even ballooning that, because again, like I said to the other gentleman, you guys, your relationship is way beyond me. Like, even in the trial, it came out something about the two of you, for whatever reason, meeting at a motel for whatever reason. That had nothing to do with a car or transportation. That was a decision. But your job is not at the motel. You see what I'm saying? So there are decisions being made every step of the way for you two to continue this involvement in some form. You know, that right there was a shocker to me, because that was a violation of my order.
I'm just trying to break free from her.
Okay. So this is what I'm going to do. The bottom line is that, as like I said, when it's domestic violence, my goal is to try to work it out because emotions get involved, people get hijacked, and I know we can work past that. But what we can't work past is the violation of the no contact order, because I'm serious about that. So on the violation of the no contact order, it'll be 180 days in jail, and I'm going to put you on probation in regard to the cases, both cases, so we can deal with anger management. But what I will say is this, though. Ms. Croup brought up the fact that she believes that you can, and I haven't assessed you, so I don't know what's going on with you drug-wise or mental health-wise, but when you get to the county and deal with this time, I believe there are programs that you can enter. Am I correct? They still have programs? Do they still have programs that he can enter?
You know, Judge, I don't know at the county, but I do know that he is dropping from the county, you know, from the probation officer that was.
Okay, so you're denying
I'm
that,
not-
okay.
Yeah, so I'm not sure that he's on anything.
Okay,
Drug-free.
okay. All right, yeah, I mean, there was nothing that came up in
And
that
I think
regard.
he's been in custody for about 12 days, Judge, so that should be credited.
Yeah, we'll give you credit for the time that you've done. So, Mr. Gilmore, that's gonna be this,
Strong arm robbing me and using the police to do it. She's been robbing me since the beginning of our relationship for money, and I just want to break free.
but understand, Mr. Gilmore, this is the chance to break free. At this point, let's be done with this. And when you get out of this jail term, the court will do what we can to help you in that regard. Yeah, I'm gonna do that, so we can bring him back here. So we don't have a warrant out and have him arrested and things like that.
How many years is he on probation?
Oh, well, I'm getting credit for 12, man. If I get the credit for 12. All right, so what's this? So actually, yes.
Probation, how long?
So what I'm gonna do is, actually, it won't be 180, it'll be 170. So I don't max him out on that. But I still think I could though. And then, but I'll ask you that before we leave. The probation term is gonna be 2 years. But what's your understanding? Bailiff Sam reminded me, he said that if the jail time is maxed out, then there's no probation?
No.
Okay. So you was gonna let me do that?
I mean,
You was just gonna walk out here and let me do that? Oh, okay, all right. See, you can't trust the
I didn't
defense
think
attorneys.
No, I didn't think about it.
They
That
only
didn't
care
cross
about their
my mind.
clients.
What I was thinking was, that he would be done and that would be the end of it. I didn't expect.
We
the
gotta.
probation
I just
to
want him to
be
come
after.
back so we can just figure this out. Just ease him back into it. I'm not gonna put him on anything extensive, but I just want to figure out where they are and make sure that those two aren't being toxic anymore. So it probably won't be a long term.
Probably, no. Are we off the record?
Yeah.
Oh, no, we're gonna see them again.
Him?
Yeah.
Both of them.
Oh, you're saying one day?
Oh, we're seeing him again.
She said she took care of the car issue.
Listen,
I'm about to. Give me a second.
I don't
I'm
care
gonna
what
clear
she
this
did.
mess up.
That car's in his name. She'd have to sue him
Right.
civilly.
So
I don't know what I
he's
told
speed
her.
10, so he's doing.
You have to go, you have to get it his car.
And
And
listen,
he'll
he
keep him on
is
150.
terrible. I drove out of here. Listen, I drove out of here. I saw
But it is programs.
all the police there and I saw her and I was like, oh no, I
Yeah,
called
he was here
her.
because
She was like,
Robert Long did. He
I
didn't
know.
have management. He was in
I mean, he literally walked right out of here and that was a good trial. That wasn't not guilty. I mean, I love Judge Dawson. That was not guilty, okay?
That's what he should do.
And
He must know he about to be gone for 6 months.
They're toxic,
he-
and they, and
I don't think that
they
registered to
from,
it.
and they wanna go at it.
Right.
It doesn't make any difference.
All
It's just like, also Miss Brown, Sylvia Brown, and Miss Williams,
yeah.
they just
could have
go
put him
at
on
it.
probation in this case.
But I ain't gonna let him concurrent. You're right, and I wouldn't have to worry about it. But I'll do that.
Yeah, we
But
don't
you're
know
right,
nothing about that one.
because I did disorder.
Well, she's
Is this a
mad.
child
She
journal?
might say he's
Right.
But this is not the journal.
And he's mad.
Yeah, you could have had 180 probation.
This isn't even happening with her.
She said her mother.
Can't leave it like this though, on this point.
She didn't come to me and say nothing about that.
Yeah,
She said something about
she
the chair
would've
and
said
stuff.
No, she gonna say she negotiated.
Now, I have a question.
To give her mom
Is he gonna hold some of the time back?
He did, he held back 10 days.
And you know, I'm at your mind. I need a trial journal. You know what I mean? You gotta-
Okay, cool.
Okay.
And then you can have a great day.
I got 2 days with you, right?
Give her, check the 18 for me.
Okay, well, I won't know until, because I prosecute for the Metro Parks, and I have to be in person in that court. in
Oh.
Fairfield. So I won't know until cases come up.
Oh, okay.
Well, not that day, probably a week before.
See you later. Take care.
See you,
Guess what that means? You may be prosecuting in these plea rooms. Have you heard about that? They're trying to get signed.
Oh, bye. No, what's going on?
They're trying to
Oh, do the Metro Parks.
bring the Metro Parks to
Oh, they're buying
Forest Hills.
property here?
Well, they're trying to, it's so political, it's hard. Forest Hills Park. They're trying to make that a metro park.
Oh, all right.
But it has to, I mean, I don't know, it's
Oh, I
like,
know,
a lot of
Darnell
hoops.
ain't coming down here, so look at that.
yeah.
I know she ain't coming.
So what happened here? Disorderly conduct, what's the, oh, July 20th when she's
You
meeting.
took off the 15th, right? Because I'll be in the.
Right.
That's why I was open. I'm like, oh yeah, I'm open. That's why.
It's cool, thank you.
Thank you.
Okay, special hearing to separate property on July 28th. Remind me of that, because I know we're gonna forget. That's gonna be, you can tell it's gonna be messy. All right, that is that. Gilmore, we need a new trial journal. Man, I can't. It's just so sad to see how toxic that situation is.
But I can't see me arguing with somebody's mom. If you tell him to sign my title, I will give you a key back. Anyway, why did you put your car in his name anyway?
It's a lot of different names. One's in the mom's name.
If I was his mom, I'd be cussing her out too. You don't negotiate. My old lady, you gonna give me my key to my car?
Right, just give me the key. You know, I ain't got nothing to do with you and my son. Just give me my keys.
That's great. She 40 years old on this stuff.
All right, I'm gonna answer some of these questions. Yeah, yes, you do. Watch who you with. All right, so that's that. Need a new trial journal on that. Thank you, gentlemen. All right. Answer some questions here. First of all, I always inform you all that based on the 6th Amendment of the Constitution, court is open and public, which means you have no right of privacy in regard to your court hearings. So, when I do choose to allow you to listen to the court proceedings, it's not a violation in any way. Some courts are on 100% where you can see the defendants' faces. I don't do that because I give them just that respect. That's just my personal choice. But I know I always get that question as to whether or not it's legal to stream a court proceeding, and the answer is yes, it is. Yes, it is. All right, let me see if there are any other questions. I always like to get that out the way first. How you feel, Judge? You're not to enforce our feelings. It's a matter of judge. You are a judge in the case and do so constitute. Interesting. So a person said it doesn't matter. You know, so interestingly, let me see on that comment. There was a person who said, a person named Cameraman, said it doesn't matter what the judge feels. But here's the interesting thing. You are so absolutely wrong. Period. That's why you do not want to get caught up in this legal system, because you are dealing with judges who are human beings. When a judge gives, the judge that gave R. Kelly 30 years in prison felt a certain type of way because the judge could have given him 0 time or 50 years. So when you are dealing with a court, you are dealing with a human being who has feelings, a judge who has emotions and has particular, feelings about certain crimes. So don't think for any second that you're not dealing with a human being who's making decisions based on how they feel about the case. So it's interesting to hear that. So I think that's important because people get caught up in this system all the time and don't realize the moment you get caught in this legal system, you have absolutely no control. So let me go with a few more questions. It's after 12 o'clock. We'll get out of here in a moment. There was a time in this country where there had to be a victim of a crime. I'm not sure what that statement means. Let me see. Okay, so the person on the other one to respond back and tell me I have duty. So all I can say in that regard is thank you for being my boss and telling me, I guess, your law degree and your experience as a judge, you can mentor me and let me know. I've been doing this for 11 years, But that person will end up in somebody's jail. That person probably has issues with police officers. that person probably has a criminal history. Because what that person doesn't realize is that even the police officer that pulls you over has feelings. It's a person. So when that police officer pulls you over and says, you know what, sir, you were going 80 miles per hour, but I'm gonna let you go right now. He's doing that based on a feeling. Or if that person says, you know what, you were going 80 miles per hour, I'm gonna arrest you right now. I'm not giving you just a ticket. Matter of fact, I'm gonna give you a ticket for speeding, reckless endangerment, impeding the flow of traffic. He's doing that based on feelings. So don't ever get it twisted and think that when you are in a situation that's dealing with the legal system, you are dealing with people. Now, laws themselves don't have feelings, or they're not supposed to, but they do also. Because think about it like this. When the Supreme Court overturned Roe versus Wade, every single judge was acting on their feelings. And the majority changed the law. Period. Those judges were acting on how they felt that the law should be interpreted. You get what I'm saying? So what I am saying, sir, is that I respect what you're saying, that judges have a duty. We swear, we have an oath, and we're supposed to uphold the law. But when you hear a set of facts in a trial, the judge then has to use their inner feelings about the case to make a decision. Do I believe John Doe, or do I believe Jane Doe? How do I feel about the testimony that John Doe gave versus how do I feel about the testimony that the witness gave? And you bring all that together and you make a decision. Same thing happens with a jury. If you have a jury trial, when the jury goes to deliberate, what they are doing is looking at the evidence that was presented, and they're determining whether they believe it to be true. And that belief is based on how they feel about the evidence. But I like that. You brought up a very good subject. By being objectionable, you brought up a very good subject that I think people need to really think about, that once you are in this legal system, yeah, there are areas that are very black and white, but there are also areas that are very gray. And those are the areas that you want to be, more mainly concerned of. For instance, if you go to trial, you never know how that trial is going to go. In fact, if you look across the country, America, you'll hear certain situations like, hey, you don't want to go to trial in front of Judge Joe Brown because Judge Joe Brown, just using him as an example, has a bias against domestic violence. He hates it. Why? Because maybe his cousin was involved in domestic violence and he saw it when he was a kid. That's a judge who you don't want to be in front of with a domestic violence charge, because that human element will come out. So yeah, it's very interesting. But that's the thing about navigating this thing called the legal matrix. Let me see, one other thing. Breaking there. Oh, did he say he's doing 80? Oh, okay. So the person that's on this other venue said that the judge is a servant of the people, which, and that's the thing. I think this person on this other he's never watched my broadcast, so he doesn't know how much I actually serve the community. That's exactly what I do. I am truly a servant, and that's how I take it. I'm not above anyone, but I have to do a job. So when you're looking at the facts presented, you got to make a decision. And this person said basically that by enforcing my feelings, I am breaking the law. Yeah, that's interesting. But that's just, unfortunately, after a while, those types of conversations just become a bunch of nonsense, period. That person that's talking can't possibly believe what he's saying. And if he does, it's just a bunch of nonsense. And I can't imagine what that person does for a living or the educational level. Not reading, but, actually educational level that the person has, because it just sounds ridiculous. But the bottom line, I think our takeaway, because those who watch my videos know that my goal is to make sure you understand a little bit more about this legal system. The bottom line is that when you are in court and your case is in court. At that point, if you are going to take a matter to trial, it's unfortunate because you no longer control the outcome of that trial. You no longer control how the judge or the jury is going to feel about the testimony or how they're going to find the testimony to be. There's no guarantee that what you say will be believed, and there's no guarantee of what the victim or other witnesses said, how they're going to be believed. But it's a crapshoot. Going to trial is a crapshoot. But I will tell you what is not a crapshoot is when a judge gives you a particular order, specifically a no contact order, you do not want to break that order because you'll end up going to jail. So that's what happened to the case I had this morning. As much as it's possible that maybe there was something else going on between the parties and maybe he didn't commit domestic violence, one thing for sure is that he violated my protection order. He walked out of this courtroom, and because he was upset about his vehicle, he decided to confront the victim even when I told him not to. And that simply can't be tolerated because one of my duties, as a person was telling me, with handling these cases is when we set bonds and let people out of jail, we're supposed to make sure we are trying to do our absolute best to protect the community. So with protecting the community, if I give you a no contact order, you cannot contact the victim, period. And ladies and gentlemen, I know domestic violence has a lot of elements to it. You know, people are in love, there's a lot of emotions, but you have to listen to the order of the court. All right. Any last questions before I end this in 3 minutes? What if the victim contacts him? Great question. I tell people all the time, if I give you a no contact order and the victim contacts you, don't talk to the victim. Walk away from the victim. Because that victim likely knows that there's a no contact order and that victim decided to be toxic enough to contact you, knowing that you can get in trouble. You see what I'm saying? So don't allow somebody to set you up because as soon as that victim gets mad and they call the police, you are going to be the one in trouble. All right, let me see. Thank you for muting whomever you did, Elsie. Let me see. What are you having for lunch? How long have you been doing this? I've been a judge for 11 years. 11 years as a judge. Do you have to be an attorney before becoming a judge? Yes, absolutely. Let me see. Oh my gosh, this other dude is absolutely, now he's gone into the area of just really weird. Let me see, you will be back on live today. No, there's no more court. Yeah, so basically everything that happens in court, every single aspect of court is open and public, unfortunately or fortunately in this country. One of the things that you have as a right in America for sure is the right to privacy when it comes to your medical history. So that's why there are HIPAA laws in regard to diagnosis and treatment and drugs that people are on and treatment that people are receiving. But other than that, everything, even sidebars, you know, those are public. The reason that you do a sidebar is because basically most times in a sidebar, to give you an example, the attorneys are saying something that they don't want their client to hear at this particular time. But that's all pretty interesting too. Last thing I'm going to mention is keep in mind the reason that in America that we even set bonds, the reason that there is a bond system is for two reasons mainly. One is to make sure that the person who you are setting a bond for returns to court. That's reason number one. And the other one is you set a bond to make sure that the community and public are being properly protected from the person who is accused of making the crime or committing the crime. That's it. That's elementary ABCs. Look it up. That's why you set a bond. When you set a bond for $1 million on a murder case, it's because you don't want the person, one, to not come to court, and you don't want them to go out and commit another murder while they're on bond to your court. But hey, all right, let's see if there's any other. Let me see. Are there any other issues or questions that they may have here? Do you believe the phrase guilty until proven innocent? No, I don't. Everyone's not guilty until they are proven guilty or they plead. Let me see. New Zealand is watching. Hello. What made me want to become a judge? The reason I decided to become a judge is because I wanted to do more to actually help people. I don't know if you caught the interaction that I had with the young ladies earlier, but when I have a chance to catch people at this stage of their life when they're making mistakes that could possibly cause them to go to jail for the rest of their lives, but I'm able to give them a break, give them wisdom, put them in a program. That's what my mission is, and that's why I became the judge. And that's what I like to do. Somebody said, what is a sidebar? A sidebar is when I call attorneys up to talk about, basically a sidebar is when you're saying something that you don't want the defendant to hear. So my sidebar, I was just letting the attorneys know, that I'm really concerned about this guy's continued propensity to violate my orders. No matter what I tell him, he continues to contact this woman. And at some point, if that woman wound up hurt or dead, the news would come and say, hey, guess what? Judge Dawson gave him a personal bond. Judge Dawson knew that he was contacting the victim and the judge let him out. The judge didn't do anything about it. The judge didn't protect this woman. It happens every day, all day across this country. That's why our protection orders are so important. So what I'm going to do is come on Wednesday and do question and answer, straight up question and answer. I do that after I am done with court. I log on so I can answer your questions to see if there's anything else that you guys are willing to do or that you need to know. Let me see. Somebody said, let me see. Thought you were doing a court TV show. No, not technically. I've been on a show called Chaos in the Court. It's aired for 2 seasons on Discovery. You can check it out maybe. All right, let's see if there are any other questions that make sense. Okay. No? Other than that, ladies and gentlemen, be blessed. I hope you can be the best you can be. Make sure that you do your absolute best to avoid getting caught up in this legal system. It is a difficult system. You know, you want to avoid negative interaction with the legal system, and it starts with the decisions that you make right now. So as we end this live, hopefully you will move through the rest of your day, the rest of your week in a way that you are avoiding negative interaction with the legal system, because even though you can be found not guilty of a crime, just the fact that you are detained, arrested, and accused can change your life. Don't allow this legal system to destroy your life. Take control, take charge. Oh, and what I always do, if you are not following me on Instagram, which is where I put most of my content, legal cases, you know, just wisdom and things like that I've learned, check me out at Judge Dawson. Or if you're interested in receiving my free email, I give it out at least once a week. I got to get the one out from last week. My website is judgedawson.com. The email is free. All you have to do is sign up and you'll get it from me. All right, be the best you can be.